Hello and welcome to Book Circle. I'm Earl Weinberg and this is our guest author, Albert Bender. He has written The Prosecution Never Rests, Strange but True Stories of Courtroom Drama. And could you tell us, please, how you came across these stories?
Well, Earl, they're stories of incidents that happened during my career.
And you were a prosecuting attorney?
I was for almost 37 years.
Mm-hmm. Where?
In Santa Clara County, California.
Okay. And when were those 27 years?
Well, I began when Lyndon Johnson was president. Can you believe? We're talking 1968.
Okay.
And I retired 12 years ago.
Okay. And when did you begin writing the book?
Well, it was long after I retired, and as I had time, a little more time than when I was working full-time, and as I began to think about my career and the changes that I saw, the incidents that happened to me, I thought some of those things are really maybe unusual, maybe interesting, cutting edge, and maybe never to be seen again, so I started making notes.
I see. So, did you do it just off the cuff, or did you have a system, or did you develop a system as you were writing the book?
Well, Earl, I developed a system, but I started out pretty loosey-goosey. In fact, I always carry a daytimer. My kids kid me about being old school, but you know, I have a place that I can make a little note. Mm-hmm. And then since I have a laptop, and especially if I travel, like to visit the kids, because they live around the country, like here in New Hampshire, I would begin to bring out a new word processing document called book or something and make notes. And pretty soon I'd make more and more notes. And then at some point I'd go back and say, okay, I'm going to fill this one out, and I'd write a whole chapter.
Oh, okay. And the total process took about how long?
Oh my, I'll bet it was 5 years. It took a long time because I didn't stay at it very consistently.
Okay. So it's a memoir is what it amounts to.
Yes, you'd call it memoirs in terms of its genre. It's memoirs of things that I experienced and saw and was involved in during my career as a prosecutor.
Okay. Would you care to select a story?
Well, there's, as you may have mentioned or not, there's a lot of stories in here, and there's actually 40 stories, and almost all of them are self-contained. So they sort of progress from when I was very young and when I started handling minor cases. We even handled, as prosecutors in California, traffic offenses. So if a person received a ticket for speeding and they wanted a jury trial, they'd get it back then, because you could actually go to jail for 6 months. Almost never happened, but it was allowed as a part of the system in effect. And so if the person wanted a jury trial, they get a jury trial, and that means the prosecutor has to come in and in effect present the case for the police officer.
I see.
So one or two of the stories at the beginning talk about that. Another story talks about what happened with a justice of the peace when he started kind of going off the loose end. That's chapter 5.
Okay, well, why don't we try that one? Chapter 5, you want a jury of your peers, ? This justice of the peace did not take pleasure in the time he had to spend on the bench. Duck hunting was his passion. But when the circumstances necessitated judicial business, he really enjoyed himself when the sheriff brought into the courtroom the inmates who had recently been arrested and were scheduled to be arraigned. Arraignment was then, and still is today, an important legal procedure which included advising each defendant of his or her rights, reading the complaint, and determining whether the defendant had an attorney or was eligible for free representation by the public defender. When a defendant would plead not guilty and request a jury trial, the justice, who knew that a jury trial was a time-consuming process and one that he wanted to avoid if that was feasible in any manner, would often ask the inmate, "So you want a jury of your peers?" The defendant, knowing what that meant, inmates are quite savvy with basic legal terminology, would naturally have to respond that he did. Then came the fun. Referring to him by name, he would ask, "Excellent, Mr. Miller, we have several of your peers sitting next to you," referring to the other inmates waiting to be arraigned. "You can have a trial by a jury of your peers right now. Why don't you just tell them your story?" Well, so much for any rules of procedure, the right of counsel, the right against self-incrimination, or other such esoteric but critical concepts that have been instilled in me during my recently completed 3 years in law school. As the reader probably recognizes, a defendant has an absolute right to counsel and cannot be compelled to testify against himself. Any question directed to a defendant at his arraignment other than "What is your plea?" and "Do you have an attorney?" is totally inappropriate and constitutes a serious violation of his or her constitutional rights. Requiring the defendant to tell his story, meaning "Tell us your defense to the charges," was a serious breach of constitutionally required procedural due process. More often than one would suspect, the inmate was foolish enough to accept the invitation and relate his defense to his peers. This is always some variation of the Charlie story. Some unknown guy named Charlie was the real criminal. Then the justice would turn to the other inmates and ask how they would vote. Guilty was always the unanimous response. If nothing else, criminals are well aware of the phoniness of the typical defense. In fact, they utilize those techniques themselves when given the proper opportunity. My 6-month tour of duty in this courtroom was unpleasant and difficult for me. The shenanigans that went on there were continual and numerous. The 6 months I served in this assignment was a painful experience for me. My wife later reminded me that I actually broke out in hives during that period of my career, obviously due to the stress of the situation. When my term was over, I was delighted to receive a new assignment at the main office. The case of hives immediately disappeared and never returned. It was not too many years later when we heard from our colleagues in the local newspaper that an extrajudicial event had put this justice at the wrong end of the law. He apparently became upset over what he perceived as unnecessary noise coming from a nearby power pole. He picked up his shotgun and fired off a round at the utility man who was working on that pole. Fortunately, the shot missed, but that incident effectively ended his career as a judicial officer. I never relish the unfortunate circumstances in which other people find themselves, but in this instance, I could not conceal my delight. This justice of the peace would never again terrorize the legal community with his unorthodox and inappropriate methods of dispensing justice. Okay. Any follow-up on that or additional detail?
My goodness, this was a long time ago, and we're talking 1969, 1970. Of course, much has changed. I have to speak about California. It's the only place I've practiced law, but we don't have justice courts anymore, and we don't even have municipal courts anymore. All our trial courts are superior courts.
Oh.
So this kind of justice doesn't exist anymore. But when he was there, that one chapter, and there's actually others, I won't bore you with them, showed the kind of things that happen, which as a recent graduate of law school, I'm just shocked. I can't believe that you actually would do this in a courtroom. And I'm, as that points out, I got really upset and nervous over it, and I was glad I got to go to other assignments.
Right, yes. I don't suppose as a beginning lawyer you felt you could say, "I object to any of this."
No, you're stuck when you're in a courtroom. The judge is the law.
Right.
And especially in lower level cases, I'm not even sure there was a court reporter at that point, probably, but you don't have any remedy. I mean, the judge is in control, and there's nothing you can do about it.
For me and for other people who don't know the difference, what is the difference between a superior court and the, suppose, inferior courts?
Well, in terms of trial courts in the state system in California, we used to have 3 tiers. Justice courts in small communities, and then you had municipal courts, which were the general courts for small, less serious offenses like misdemeanors, and the original courts for felonies. And then you had superior courts, which where the felonies were tried.
Oh, I see.
And then, of course, the civil depend upon the amount in controversy.
I see. Okay. All right. You mentioned traffic problems. Was the one about Judge Chesterfield a traffic problem?
That was the judge we just talked about.
Oh,
We
the fellow
later-
who wound up trying to take a
Right.
pot shot at
Yeah,
a blind man.
We later had a problem with the judge in the municipal court in San Jose, and there's a couple chapters about him also. They're a little longer, a little more involved. But fortunately, he actually got defeated for re-election. He was so bad. He was so incompetent
Oh, dear.
that one of our colleagues took him on and beat him, which almost never happens. Yes, I got to appear in front of him a few times, and that was also rather painful.
Did you ever, were you ever a judge yourself?
No, I seriously considered it and going through all the process, and then changed my mind and decided
Okay.
not to do that.
Right, well, looking at the company you might be keeping.
And the book progresses to more advanced cases, of course. There's ones involving homicides, psychiatric defenses. Some of those are interesting also.
Would the Angela Davis one be an example?
That's interesting because of what happened in the courtroom.
Oh.
Yeah, I was not actually involved in that case, but I got caught up in it in one very interesting way.
Well, if you don't mind, I'll read that one to our audience.
Sure.
Angela Davis comes to town. As I began my third year as a prosecutor, I was already handling felony cases. In those days, access to the courtrooms, which handled criminal cases, was simple. You just opened a door and walked in, and you exited in the same manner. With a heavy caseload, I engaged in this behavior frequently and by rote. Young readers may find it hard to believe that only some 35 years ago there was absolutely no courtroom security. But the same was true with regard to air travel. I began flying in the 1950s, and while employed as a prosecutor, my job assignment often required a trip to Los Angeles, San Diego, or Sacramento. I always flew on PSA or AirCal. You simply entered the terminal, located your gate, and boarded the plane by climbing the portable steps. Jetways came much later. Some planes even had built-in stairways, such as the rear exit on Boeing 727s, made famous by the D.B. Cooper escapade. In August of 1970, a heavily armed young man took over a courtroom in Marin County, another Bay Area county, and then took the judge, the prosecutor, and 3 jurors as hostage. During the ensuing melee, the judge was shot and killed, and the prosecutor severely injured. The authorities soon discovered that the murder weapon had been purchased just 2 days earlier by Angela Davis. Angela Davis, an activist and professor at UCLA, was allegedly a member of the Communist Party and closely associated with the Black Panther Party. A few days later, an arrest warrant was issued charging her with kidnapping and first-degree murder. When she was finally arrested, the trial was transferred to Santa Clara County on a change of venue motion. It would clearly have been difficult to obtain a fair trial in that county. Its citizens, some of whom actually knew some of the victims, were still reeling from the recent alarming and distressing episode. At that point, everything changed. The courthouse where criminal trials were held became a veritable fortress. The fear of an attempted takeover, such as occurred in Marin County, dictated new and extensive security measures. That included searches upon entry and very limited means of egress as well. New mandatory methods of exiting a courtroom can catch an inattentive person by surprise. Not that I was really careless, but the habit of hastily exiting through the same door day after day can impede your ability to observe the obvious. I am sure the door was clearly marked, but after making my short court appearance on a particular case, I stepped into the hall and began to exit through the door I had always used. Mistake. Suddenly, very loud alarms began to sound throughout the entire courtroom complex. Well, that certainly gets your attention, and it got the attention of security personnel as well. Since they all knew me well, they merely closed the door and reset the alarm system. But I was then told something that clearly revealed to me that I was not the first person to make that mistake. The presiding judge, the officer told me, requires that anyone who sets off the alarm by accident must enter his courtroom and personally apologize. It is rather embarrassing to have to open a courtroom door when the court is in session, thereby interrupting the proceedings, and have to address the judge and everyone in the courtroom with the admission that I was the one responsible for the alarm that disturbed them, that I apologize, and that I will try to be more careful in the future. But there was no option. That was what I had to do. Fortunately, the judge knew me well and was most considerate. "Thank you, Mr. Bender." That was it. I left the courtroom, located the correct and only exit door in the courthouse, located next to the metal detector for people seeking to enter the courthouse, and retreated to my office.
Some things you never forget, Earl.
No! That sounds very memorable.
Yes, that definitely set off an alarm, and when you have to go in there and here's the court fully in session.
Mm-hmm. Everyone
Looks at you, you know.
I suppose you're used to having everyone look at you, but not that way.
Exactly, not as the villain who just upset the whole apple cart. It's just good that I knew people, they knew me.
Yeah.
But still, it's a very embarrassing sort of thing to have to happen to you. So.
Oh, good grief.
Yeah. I never did it again.
No, I'm sure you didn't. I'm sure I wouldn't.
It never happened again.
Well, would you want to find something that's embarrassing to someone else?
Oh yeah, I bet there are things that are embarrassing to someone else. Actually, this one I got a kick out of chapter 38.
Okay.
Embarrassing in a way that was kind of really funny, I think.
Oh, yeah, well, what a great title. 183.
I was trying murder cases then, and this is one of those situations that came up.
Sorry, fumbling the pages here. There. The psychiatrist had warned his colleagues that they must be prepared to bleed. On some occasions, such as detailed in the prior chapter, I came to the conclusion that forensic experts were quite comfortable in rendering opinions that were unrealistic and indeed spurious. They really knew better, but were paid handsomely to develop any possible medical or legal theory in an attempt to convince the jury that a defendant who killed another person was not fully responsible for his behavior, even though objective evidence indicated otherwise. But on at least one occasion, I was amazed to find that the expert who testified that the defendant lacked the capacity to conform his conduct to the requirements of the law, one aspect of the legal test then applicable, actually tried to respond honestly to the questions I asked, even though the answers to those questions would raise serious doubts about the trustworthiness of his medical or legal opinion. On that occasion, again a murder trial involving an insanity defense, the defense produced a forensic psychiatrist who I recognized as having been a speaker at a conference on mental defenses, which I had attended a few years earlier. We had never met, but I had a syllabus and extensive notes regarding his presentation. When I discovered that he would be testifying in this particular murder trial, I located that material and reviewed it thoroughly. The cross-examination of Dr. Whitman went very well indeed. Unlike most forensic psychiatrists, he actually tried to deal with my questions while still clinging to his opinion, rather than deliberately avoiding a direct answer, as was the response I normally received from forensic psychiatrists. After about 2 days on the witness stand, it was clear that despite his protestation to the contrary, his opinion about the defendant's mental state had been greatly weakened during my cross-examination. My final question of Dr. Whitman was, "Doctor, is it correct to say that during a conference regarding mental defenses at which you spoke, you told your audience that in matters such as this, the psychiatrist must be prepared to bleed?" Without missing a beat, Dr. Whitman promptly replied, "Well, you certainly can expect to get scratched and suffer a wound or two, but this amount of bleeding is quite uncalled for, quite unnecessary." The courtroom erupted in laughter. I sensed that the jury loved it. I was finished. That was my last question. When the jury eventually retired to deliberate, the verdict rendered was not manslaughter as the defense had hoped. The defendant was found guilty of murder, which meant that the jury had rejected the defense based upon psychiatric testimony. I suspect that my view of psychiatric defenses was in some respect influenced by an experience I had as a very young lawyer. Before becoming a prosecutor, I worked for a couple of years with a firm in a small town, and we practiced primarily business law. The United Supreme Court had recently ruled that every criminal defendant who could not afford an attorney was entitled to representation at public expense, but the county in which I was practicing had not yet created the public defender system. Therefore, young attorneys were expected to participate in a pro bono program. This meant that you would receive a telephone call from the presiding judge requesting that you appear in court and represent a particular defendant who had been charged with a crime. The program was pro bono because neither the firm nor the attorney was compensated for such legal representation. Although the details of one such assignment are vague due to the passage of almost 5 decades, the conclusion of the case made it exceedingly memorable. After receiving such a call from the presiding judge, I walked over to the jail to meet my new client. I was immediately informed that he had assaulted a jailer and had attempted to escape, so he was currently unavailable. I wondered at the time what that meant, but did not ask. A couple of days later, we met. I introduced myself and explained the situation to him, including both the original and the new charges that had been filed, which were very serious. I also explained the courtroom procedure that would follow. He was intelligent, a good listener, and asked the questions that one would have been expected to under the circumstances. When I finished, his response astonished me. He told me in no uncertain terms that he expected me to enter a not guilty by reason of insanity plea on his behalf. First, this demonstrated that this defendant was more than normally savvy about legal terminology and proceedings. Secondly, his conversation with me had not revealed any evidence of any type of serious mental illness, such as a psychosis. At that point, I was obligated to explain to him that the court would appoint mental health experts to examine him to determine whether he was in fact insane. He looked at me with an amazing demeanor and politely told me that he could deal with the situation. I was, of course, duty-bound to honor his wishes. Also, I was thoroughly convinced that if he was not insane and was just malingering, the court-appointed psychiatrists would recognize the fact. Due to the passage of time, I cannot recall the procedural context, but I know that either by entering the insanity plea or by invoking the procedure in the penalty code for deciding a defendant's mental competence to understand the nature of the criminal proceedings and to assist counsel in the conduct of his defense, I succeeded in having the judge appoint 2 psychiatrists to examine my client. When the psychiatric reports were prepared and submitted to me and the prosecutor, I was totally shocked by the contents of the reports. Both psychiatrists were of the opinion that this man was suffering from a serious mental illness which was characterized by symptoms of hallucinations and delusions. He was indeed psychotic. Being his defense attorney and just out of law school, it was not my duty to argue with these findings. It was my obligation to act in the best interests of my client, which meant I must submit the matter on these reports. As my client left the courtroom to begin his journey to the State Mental Hospital for the Criminally Insane, he glanced at me with a look that seemed to say, "I told you so." This incident haunted me for years. It also served as confirmation in my mind that indeed mental health experts can be fooled. They are not infallible, and their opinions should be challenged. This is particularly true when a psychiatrist or psychologist is retained and paid by a defense attorney and therefore necessarily has a bias toward producing findings and opinions that favor the argument being advanced by the attorney on behalf of his client.
Oh, yes.
Oh, my. So, are psychiatric examiners ever brought in neutrally or on the side of the prosecution?
Well, yes, they are, Earl. In my career, they generally were brought in by the defense because the defense wants to establish some mental condition which will lessen the crime, such as from murder to manslaughter. Mm-hmm. The readers or the listeners may be remembering things like the attempted assassination of President Reagan.
Yeah.
And the defense there was insanity, and the jury bought it. Mm-hmm. They found him not guilty by reason of insanity. Some jurors may, or some listeners, viewers may remember, if they're from California or it got national news, the time that Dan White came in through a window in the courthouse and proceeded to murder the mayor, Moscone, and the supervisor, Harvey Milk. And there again, they put on a diminished capacity defense, which meant that experts from the profession came in for the defendant. Mm-hmm. The jury bought that too, and that caused tremendous rioting and all kinds of things. What appeared to be 2 cold counts of first-degree murder went down to manslaughter. Mm. Now, there were times where, as a prosecutor, I would bring in a psychiatrist, but generally speaking, I could not do that because I had no access to the defendant. The defendant didn't have to talk to him.
I see.
So he had no way to say anything. Sometimes we brought them in what we called a debunker. And the debunker would say, what that guy just testified to is nonsense.
So you would have dueling psychiatrists.
Well, they wouldn't quite duel. The one would have an opinion, and the other would say the opinion junk, I have no opinion. But I can tell you that the opinion of the defense psychiatrist is garbage, and here's why.
I see.
And you basically say, you as jurors have a much better way of determining whether this guy is insane or not based upon all the evidence you're going to hear. And every now and then a court will appoint the psychiatrist. Sometimes, like the one we just talked about was court appointed. And so if the defendant will talk to him, then you get somewhat of an objective opinion, at least not influenced by who hired me.
And I presume that being sent to a mental hospital as criminally insane is preferable to being sent to prison, or of course...
Very much so.
Right.
Yes, they much prefer that to going to San Quentin or some prison.
Or, and of course, if there's a death sentence involved.
Right.
Well, why don't we conclude with one more of your selection?
Well, let me see if we have a short one. Well, this one's kind of funny, and it's pretty short, chapter 29.
Okay.
I'll bet that rarely happens to anyone. I was trying mainline felonies at this point, not murder cases.
Okay, but it's certainly got another good title. A lid of marijuana ends up on my desk. At this point, early in the 21st century, marijuana is widely available. One can purchase it at a storefront, and possession for personal use has been widely legalized, with exceptions, including federal statutes. So it would seem strange to envision a situation in which even possession of more than 1 ounce of the drug was a felony and could put the user in state prison. However, that was the reality in 1968, the year in which I began my career as a prosecutor. And longer prison terms were prescribed as cases alleging as cases alleging possession for sale, selling, or transporting marijuana. My early felony assignments included cases involving marijuana, and the defendant attorney on one such case had requested a meeting in my office with the goal of discussing the evidence against his client and hopefully convincing me to reduce the crime charged against his client, such as from possession for sale to simple possession. Such a reduction would usually mean that his client would avoid a commitment to state prison. After introducing himself and taking a chair in front of my desk, he announced the police did not do a very thorough job and pulled from his pocket an object which he placed on my desk. I quickly realized that he had placed in front of me a lid of marijuana. I found this in the site of the arrest, he proudly proclaimed. Well, apparently this attorney was unaware that whereas police and law enforcement personnel have immunity when handling evidence, he does not, except in the courtroom itself. The very process of collecting that evidence and bringing it to my office was in itself conduct prohibited by law. Indeed, he'd committed a felony and was continuing to do so by transporting the substances. Being an inexperienced prosecutor, I needed assistance with this highly unusual situation. I immediately telephoned my supervisor, who advised me to tell the attorney that he must immediately remove the contraband, take it to the police station, and surrender it to the authorities. He also exhorted me to tell the attorney to drive carefully so as not to be pulled over for a traffic violation, which, if it resulted in search of his vehicle, would then be followed by his being arrested and booked for the felony of transportation of marijuana. To this day, although I distinctly recall these events, I have no recollection of how we finally resolved this case, except I know it did not go to trial. The attorney had placed himself in a very precarious position, which would have been detrimental to his client's case had he decided to insist upon a jury trial. He had now become a witness, and not one helpful to his client at all.
That story is almost unbelievable because it's so weird that a defense attorney wouldn't do that.
Right.
Not recognizing what he's doing to himself.
I mean, you describe yourself here as a junior attorney. This guy must have been considerably sub-junior to pull something like that.
He was thoroughly incompetent, Earl. I mean, to
Right.
do that, I don't know what was cute or what, but imagine how surprised I was.
Yeah.
And to think that he's transporting, that was a felony then, and why he would do it. Is this helping his client?
Why did, yes, what was he going to prove to you other than the police, that he thought the police incompetent?
Right. I'm sure he must have to withdraw from the case or do
Right.
something because it put him in an untenable position.
You must have had a very strong feeling of get that thing off my desk right now.
I was so shocked. Wow, what do I picked up the phone and called my supervisor who answered, and
Boss?
I did exactly what he said.
Good grief.
Yeah.
Oh my goodness.
Well, you can see why I put these memoirs together.
Well, yeah.
Because things like that, I thought, that's really interesting.
I should think this would be very helpful to law students, actually, to let them know what they might be in for.
Right.
Well, thank you very much for coming by and for showing us the book and letting me read some of the stories. And how can they find this in bookstores or online?
Well, it's online, Earl.
It's online.
Yeah.
Okay.
And thanks for inviting me. I appreciate the opportunity. And
Well, it's been a great pleasure.
well, thank you very much.
And should you write another book, we will be happy to have you back.
Thank you very much.
Thank you.
Sure.
And thank you.